So now we're beginning to see how do we work through this? What are the issues that are coming up? What do we need to know? What do we need to think about? And kind of what do we need to do as we begin to work through this contract? We begin to represent our clients in these transactions, and kind of what do we need to be paying attention to? So without further ado, we're going to get going. If my clicker works. Hold on. Technology. Can't live. Oh, there we go. All right.
All right. So first off, we're going to start with going over the old RPA and where everything moved around into the new RPA. And then we'll talk about some of the specific changes that we've seen. And then we'll lead into the biggest potential pitfalls and best practices as you go through when you're speaking with your clients. Okay, so the old RPA, everyone knows it and loves it. Here's all of the various sections that everybody probably has, at least some of the main ones, memorized because you use it so often. There have been quite a bit of changes, but the majority of the change, as you'll see, if you haven't seen it already, is how everything's arranged. They combined some of the language in some of these sections, and they shifted them around a little bit, but a lot of the same language is still there. So next slide. So this is basically what C.A.R did. They just did a nice little break. And so here we use the billiards analogy to kind of show where everything landed after the big break. So you've seen the green check boxes. Those sections have remained, at least the section numbers where they're located have remained the same. There might be some specific language within those that has changed. But then if you look at the numbers on the billiard balls, that's kind of where those sections actually ended up in the new one. And yes, I know a 16 and a 27, 26 ball doesn't exist, but we had to bend a little bit of the billiard rules. So pardon me if you're a big billiards fan, especially the rules.
One thing to think about that's important is prior to this revision, the dispute resolution paragraph, that's the everybody loves to hate, mediation and arbitration and what it actually does. In the old contract, that was one paragraph, and it created a lot of confusion because there's a mandatory mediation clause in 22A, but in 22B, which is where the arbitration clause was, that was optional, and it created a lot of confusion. So in this version, it broke that up. You have 30, which is mediation. You have 31, which is arbitration. And yes, I will send this PowerPoint to Tony, and then Tony can distribute it.
All right, and so this is where everything ended up. Yeah, it's a lot of the same ones you'll recognize. 14 is still, time periods and removal of contingencies, offer and agency. 1 and 2 are still the same, but you'll notice kind of in between there, a lot of things have moved around. So the whole idea for C.A.R was to put all of the changeable or malleable terms up front. So it's easier for the consumer to be able to look at the contract and get all of that key information, everything that was previously typed in by the realtors in blue ink on zip forms is kind of consolidated right up at the front. So at one glance, the consumer can kind of see those things, and there's less chances of the, a timeline or some change to the contract getting missed later on down in the language. The important thing is to remember the rest of the contract is still there, and that's actually the binding language. So even though everything went up top, that's changeable, all the blue ink stuff per se, and the black ink stuff is actually where the law is. And so, it's important to read the whole document, and I think we'll allude to that.
We'll hit on that a few times.
So here's what the first page looks like. This should be very familiar to you. It is all the, transactional information on the face of the offer, the property location, the APN number, the parties as far as the brokers. So not a huge change there.
There's one important line, and I don't know if you guys catch it, but in paragraph 3, the very last sentence, it says the parties are advised to read all 16 pages. That was added in this agreement. And the reason is one of the fears that we have when we look at these documents, by throwing that table with all the malleable terms at the front, consumers oftentimes are going to be going, hey, this is where all the stuff is that I need to know. I'm going to look at this table. I'll be good to go. I'm going to sign it and be done. But that's a big trap. And we're going to talk a little bit about that in the pitfall section, because you really need to make sure that your clients are not taking the shortcuts and just looking at those terms, because while that table is handy, it's not all the language of the contract. It's not how the contract's going to get governed at the end of the day if this ends up in litigation. That comes from pages 5 to 16. That's where those governing terms are. So we really want to make sure that we pay attention and that clients aren't just glancing over the language.
And so this is where section 3 starts, which is the table. And as we talked about, it's where all the changeable terms are all kind of consolidated into one table. But you'll see it references the paragraph number where that actual contractual language is located. So the first column is just kind of a reference, so you know what line you're looking at. But the next column, the second one, paragraph number, that's going to be basically the billiard ball and where it ended up. So you want to definitely go to those sections using that column on the reference table. And then this is just continuing down. And you can see there's bars across, let's say intentionally left blank. And that's just to kind of separate the sections. That slide that we had earlier with the crane, that kind of shows those different sections, which is just like purchase timelines and financial information, and then going down contingencies, etc. Okay, so what exactly changed besides the whole entire structure of the form?
I'm not going to sing you David Bowie today.
So besides placing those changeable terms up front, like Keith said, there is reminders throughout that say to read all 16 pages, and we'll harp on that a little bit more when we get to pitfalls. There's verifications for proof of funds and loan application. Those are given more optional days, like the black numbers that are next to the blank space. Also, removal of waiver of contingencies at time of offers against agent advice. That language was added, and that I think is a nod to the current market that we find ourselves in now, where a lot of buyers, to get a more competitive advantage, are waiving some of their contingencies and their rights. And so I think C.A.R, seeing that as a trend, wanted to make sure that agents are protected by clarifying that is against advice to waive those contingencies.
Yeah, so one of the important parts to think about this is, and we'll talk a little bit more, but I think this is a good time to talk initially about it, is as professionals, as real estate agents, just like lawyers, we have fiduciary duties to our client. We have obligations to put their interest at the forefront. And so one of the things that is important about this, when you look at this holistically, is you have on page 1 that says the parties are advised to read all terms. But if we're not doing our job to make sure our clients, or at least getting confirmation from our clients that they've read the whole contract, the problem that comes up is something happens down the road and they turn around and they go, it's your fault. It's because it's never the client's fault, right? We've been in this business a long time. The client never makes a mistake. It's always our fault. And the first thing they say is, you didn't tell us to read the whole thing. I didn't think I needed to. That's the wrong answer. The right answer is, we advised you to read the whole thing. Here's my email that says, I'm telling you, read the whole thing. I saw when the Docusign went out and I saw when it came back and it was 5 minutes. I'm like, I'm a fast reader, but I'm not that fast of a reader. So I'm calling my client and telling them hey, you got to take a look at this, because what's going to happen is they're going to say one of these things that was added they weren't aware of. They've done transactions before. They've been involved in real estate purchases. Maybe this is their third home. And none of this language is ever in those contracts. And so they didn't know. And so they'll flip that around on the agent to say, hey, look, you guys didn't tell me. So that's why it's important to make sure we understand these changes were put in. They're put in to help you as the agent represent your client to the best of your abilities, but they're also put in to kind of inform the client what they need to do. But none of that happens unless we're making sure that they're actually reading that document, or at least telling us that they read the document.
Can you go back? There's just a couple more that change things I want to hit on. Yeah, a couple more things on here that I think are important. Security system and smart home devices were updated in the items included. And there's also language in there that says that the seller has to cooperate with the buyer's efforts to transfer that. And I think that's just kind of C.A.R seeing the addition of smart home devices. So just some language that tells the seller it has to cooperate with efforts to transfer all that stuff over. And then as you'll see on there, a couple more things. We have the appraisals for FHA and VA loans need to go to the seller with the other investigation documents. And then lastly, there's the new form fire hardening and defensible space advisory.
You skipped over that. There we go.
And so here's just a little excerpt from C.A.R on it. It basically creates a buffer zone, and this was delayed a little bit. It's
it was supposed to roll out last year, but because of COVID and some of the issues that the state fire marshal is having doing their maps and other things, it's been delayed a year. Okay, ready?
Yep.
Perfect. Now this gets into really the nuts and bolts. This is what we all really want, right? What are those biggest potential pitfalls? And then what are we doing to look so that we can make sure we navigate to avoid those pitfalls? And then what are the best practices? Because at the end of the day, we want to make sure we're providing the service to the clients that are needed. So we're going to kind of walk through those. Number one, I can't stress this enough. UPL, unlicensed practice of law. You know, it's very tempting for agents, you know, who sometimes they're new, maybe they've been in this business for a long time, and they have a really good understanding of how this stuff works, you know, and so it's really tempting for them to say, well, this is what that term means, or this is what the zoning allows for your property, or this is what your preliminary title report means and what the liabilities of those encumbrances are. You have to be really careful when you look at the law. Unauthorized practice of law includes giving legal advice and preparing legal instruments and contracts. And you say, well, wait a minute. I prepare contracts all the time. You know, I'm filling out the RPA, I'm filling out the addendums, I'm doing demands to close, I'm doing waivers, demands for waiver of contingencies. I'm filling out contracts all the time. Am I practicing law? The answer is no. This goes way back. To at least 1970, and I think it actually goes back longer than that. Filling out those form contracts is not the practice of law. That's a ministerial act. You know, you're allowed to do that. It's important to know the distinction between activities that are ministerial and those that are non-ministerial. Assisting clients in completing the RPA is a ministerial act. You're filling out the boxes. However, when you get yourself into that non-ministerial act, like you explain what the legal implications of an arbitration are, what the legal implications of liquidated damage is, going in and taking a look at the preliminary title report and seeing the exceptions and telling your buyer client, well, this has this legal effect, this has this effect, this has this effect, this may get removed, this may not get removed. Now you're providing legal advice on what does that title policy, what does that preliminary title report represent, what are the legal impacts, and then as the client's listening to that on the buy side, they're going, this is what my title policy when I ultimately buy may or may not cover. Those are the things you want to be watching for, because when you step outside of that ministerial function, that's when you begin to run afoul of the unlicensed practice of law. And there's two big reasons why that's a problem. One, well, it's a misdemeanor. We start with the fundamental premise that most of the people who write laws are lawyers, and lawyers tend to protect their own. It's a little bit, how do we say, cynical? But that's one side. But the more important side is oftentimes, you know, with your E&O insurance, if you find yourself in a legal matter and your client is pursuing you for some sort of a wrong, one of the things that an E&O provider could say, hold on, we may not provide coverage, is really in fraud. We all know that. If you do the bad boy acts or the bad girl acts and you commit fraud, insurance isn't going to cover you. But sometimes, depending on the way your policy is written, if you have a statutory violation, you do something unlawful, something you're not allowed to do, that now steps outside of the realm of a negligence action, and that may jeopardize your E&O coverage. So one of the things you want to be thinking about is if your client's asking you questions and they're related to the interpretation of a term or the legal impact, things of that nature, you want to have that little radar in your head going off that says, am I beginning to cross that line on unlicensed practice of law? And do I need to get them a referral to an attorney, to have them talk to somebody who has the ability, I don't like the word ability, but who has the legal authority to actually provide that information and to provide that advice. So you want to be thinking about it. It's real easy to find yourself crossing that line, but we just want to be aware of it. Really, and what that gets into is what we alluded to was the fiduciary duties. Fiduciary duties, as part of the UPL, also then moves into the negligence side. One of the things that we're always looking at is, what is that obligation of that realtor? The duty of honesty and reasonable care. Well, we all understand that, and we see that in the disclosure side, right? So the duty of reasonable care, if you look at Civil Code Section 2079, says that not only does the seller have the obligation to disclose those defects those material defects that are likely to affect price and desirability of the home, but the agent has that. Both the listing and the seller, both the listing and the buying agent have that. I should change that. They changed the law. It's no longer listing agent and buying and selling agent. It's now selling agent and buying agent. You should remember that. But it's both agents have that duty to disclose those information. You have a duty to investigate and disclose. Again, that gets to the statute, it gets to the DRE regs. And so one of the things you want to think about is, what is it that I have to look at? And notice it says duty to investigate and a duty not to inspect. Those are two different obligations. Inspection is a much more thorough examination than an investigation. Investigation is you're going out and you're looking. You're looking at the condition of the property and you're representing and telling them what you see and what could be an issue. Another one, a duty not to self-deal. I think this goes without saying that you can't self-deal. The NAR rules have a requirement in the ethics provision that says that if you're a party to the transaction and you're a licensed agent, you have an obligation to disclose that licensing. You have to make sure that people understand your level and your participation in this deal. Conflicts of interest and dual agency. This is always a little bit of a touchy one to talk about because by statute, real estate agents have the authority and are allowed to engage in dual agency transactions. You can do that. Now, in order to do that, you have to make sure you have those proper disclosures in place. And the RPA sets out some of the basic places where you can identify who the broker, whether or not they're representing the seller or the buyer, or whether or not they're representing both. But one thing to be aware of on the fiduciary duty side of this is that if you go all the way back to, I think it's 1919, I think that's the year. And it's Glenn versus Rice. And then it's reaffirmed in the Judy case, I think in 87. But what it says is that the notion of dual agency, when it is not disclosed, gives rise to the appearance of bad acts. And just that mere appearance of a bad act gives the courts the authority to disgorge the commission. So one of the things you want to be making sure is if you're going to engage in dual agency, make sure that those disclosures are happening. Because the legal implications for not making that simple disclosure, even if the court finds that you did nothing wrong, just the mere fact that you don't provide the disclosure can create liability. And then obviously the broker's duty to supervise. There's an obligation on brokers to make sure that their salespeople are acting within accordance of the law, within accordance of the DRE rules and the ethics. And that's something that needs to be make sure that it's monitored. So read the entire RPA. This is probably where I suspect a lot of the litigation is going to come out over the next 2 or 3 or 4 years. It's going to be because there's been changes in the terms, because the terms have moved around. People are going to be very quick to sign contracts. One, it's the market, right? We know that this market is super hot. We know that buyers are doing everything they can to get a competitive advantage to get their offer accepted. So oftentimes they're going to just skim through. It gets back to Docusign. You love it, but you love to hate it, right? Look, I like Docusign. I think it's great. It makes life convenient. It puts everything in one place. It makes sure that your buyers and sellers don't miss any places where they need to sign. It creates electronic track records to know when they opened it and when they executed it. And it facilitates that transaction really, really well. Those are all the good things. There's one bad thing about it. You don't actually have to read it. You don't, when you go into Docusign, you start clicking next, and it starts dropping your initials in. You don't have to read it. You don't have to scroll through. It's not set up so you click, you can sign your initials, and then you have to scroll to the next page and sign and then scroll. It's set up to be very, very efficient, but when you create efficiencies, there are places that create gaps. And so one of the things you want to be thinking about as you're working through this is if you see a client and you've sent them they're a first-time home buyer and they're super excited about this house. They just found the starter home of their dreams. It's priced well. They can afford it. We absolutely have to get this. And you send them that Docusign at 12 o'clock and it comes back to you at 12:15. That should trip some triggers in your head. You should be reaching out and going, hey, I'm glad that you're excited. I want to help you get the house, but I got to make sure. Did you understand the contract? Did you read it? Do you have any questions? If there are questions on the impacts of terms, I need to get you to an attorney, but I want to make sure you understand this because the law creates a presumption, and that presumption is that everybody that signs a contract that gets into a contractual relationship, they are presumed to have read and understood that agreement. It's a presumption. It is not a determination, and a presumption means that that can change. And one of the easiest ways to change it is court. We know they didn't read it. This was sent to them at 12 o'clock, and they had it signed and back out of their email at 12:15. It's a 16-page contract. Your Honor, you're a smart person. I'm a smart person. We both read for a living. I can't read that fast, especially when it's 8-point or 10-point font, and there's a lot of words between page 1 and page 16. So you want to make sure that you're watching this so that if that scenario comes up, you can say, hey, I want to get this off to the seller because I want to help you buy this, but I need to make sure that you read the agreement and that you're comfortable with it, because there's a lot of terms from page 5 to page 16 that talk about what does that table actually mean? How do we deal with it? How do we deal with disputes? How do we deal with the contingencies? How do we deal with the removals? What are the nuts and the bolts? And what are the impacts? So you want to make sure that they're reading the entire agreement and document. Failure to retain records. This is another big one. I always send, from Estella Drake, I always send the RPA in PDF prior to signing. That's fantastic. Demos, I see that too. That's fantastic. It's a great practice because you're sending it out in a mechanism that they can't sign it. They have to look at it and then they can call you and say, hey, send it to me, I'm ready to go. Now that creates a record, and because it's emailed, you've got that saved, which fits right into number 5, which is failure to retain records. That's a good thing. So the DRE requires licensed brokers must retain for 3 years copies of all listings, deposit receipts, canceled check, trust account, records, and other documents executed or obtained by the broker. That other documents also includes emails. Emails have to be retained. Text messages currently do not, but with how much we are doing the practice with this little device, we should be retaining that. There's a lot of stuff that gets communicated on this that if we don't have it, could create problems for you. Interesting. So you want to make sure you have that. Now, what does it mean and what does it doesn't mean? One thing to think about, notice that the requirement is only for 3 years. That's what the DRE says that you have to do. As a lawyer, I'm going to tell you it's longer. I'm going to tell you it's about 6 to 7 years. And the reason I'm going to tell you it's about 6 to 7 years, number one, a cause of action for negligence is 2 years. Okay, so 3 years works, because if negligence has to be brought within 2 years, I've got more time. Great. Breach of contract. A breach of contract claim, which is where a lot of fiduciary claims arise from, is the contractual relationship. That's a 4-year statute of limitations. So here's the problem. Yes, talk to Noel. Here's your problem. If the statute of limitations is 4 years and you keep it for 3 years, and at month 39, that client says, hey, you breached the fiduciary duties, I'm suing you because you screwed up. All of that file, if you got rid of it after 3 years, is gone. The only person who now has records is the plaintiff or your former client who doesn't like you. And look, I get it. Maybe I'm skeptical. Maybe I'm a little bit cynical. I've been doing this a long time, and this is what I know. Plaintiffs never sink their own ship. So if you know that you sent an email or you sent something and told them something about this thing that they're complaining about now, they will mysteriously have forgotten it, or that email will mysteriously have been deleted, or that text will be on a phone that has mysteriously now been destroyed. That information that protects you will be gone. And even though they have an obligation to tell the truth and produce all this information in discovery, they won't. And that's just the way it works. But it's not just negligence, it's fraud. Fraud's a 3-year statute of limitations. Well, great, it's 3-year statute of limitations, and this is 3 years, so this is fantastic. If I can get rid of it, then it'll be right at the time that the fraud expires. But here's the problem. Fraud is 3 years, yes, but it's 3 years from the date of discovery. The longest case that I know about where a fraud claim survived the statute of limitations was 17 years. 17 years after the fraud was committed, it still survived the statute of limitations, and it was still prosecuted, and the person who committed the fraud was still held liable. Now, I'm not telling you to hang on to your records for 20 years. That's one case. I've been doing this for almost 20 years now. I think it's 18 years, 17, 18 years now. I've been involved in thousands of cases. I've only seen that once. That's rare. But this is why you want to be thinking. The last one is, generally speaking, regulatory agencies like the state bar and the DRE. They have a 6-year statute of limitations to prosecute ethics violations. That's the other reason. When I say you want to hold it for 6 to 7 years, that's the other reason. Is because if the DRE has the authority to prosecute you further down the road, you want to make sure that you have your file to defend yourself. Because your file is what tells the investigator what happened. So that's why you need to maintain those records longer. Brokers are required to retain them. Salespeople technically aren't, but I would tell you this: retain them. You may separate from your broker at some point in time. I know that as we talk today, maybe that's not on your plate, but in 3 years from now it might be, in 4 years from now it might be, in 5 years it might be. So you may change brokerages. Well, if you change brokerages and you're getting in trouble, but your broker's not getting in trouble, maybe they've gotten rid of their records and you don't have them. So make sure you keep a copy of your file. And that's it. How fast did we go? Fantastic, Tony. I'm going to get this back to you. Do we have questions?
Click one more time. No.
What is Noel's number? Noel can be reached at the office at 916-966-2260, or you can email her at ngsmith@bpelaw.com.
Keith, I think Linda Woods had a question here at the
Okay,
end.
what was the question, April?
I think it's, what is the time period that DRE has to prosecute?
I want to say off the top of my head, it's 6 years.
6 years. Okay. In this one, in regards to EMD, would you advise buyers and selling agents to check the box and write in check if they want their buyers to bring in a cashier's check?
If they want a cashier's check, you need to identify that,
Okay.
you know?
That's what the other is for. You
Yeah.
can type in cashier's check.
Yep.
Well, thank you. That was a great presentation. And thank you again. The link is in the chat box to download the PowerPoint. So if you want that PowerPoint, or it'll be a PDF, download it right now. Let's see, any other, what was the reason for changing the requirement to provide the FHA VA appraisal to the seller?
I think we all have our own suppositions on this. Look at that. I haven't moved in a while and my light just turned off. Hold on. We all have our own suppositions on why. I think one of the things that I look at, and one of the things, maybe I'm an eternal skeptic, but we saw people pulling deals over the last couple of years because of appraisals, and using that as a reason to cancel a transaction. So especially with like the VA and the FHA, that's where you see a lot of this stuff. I think they're using and say, hey, look, if you're going to have the appraisal, then you're going to have to turn that over to the seller. Now, here's the thing you got to understand is those appraisals are not for the reliance of anybody other than the buyer and the lender. So even if the buyer does turn over that VA or the FHA appraisal, the seller has no legal authority or legal ability to rely on the opinions of that appraiser. So if you use that for a basis to set price at a later date, doesn't mean it will actually be something that you can rely on.
So when you're required to turn over an appraisal is if you use that appraisal as a reason to cancel the contract.
Well, that's what I would argue. The contract doesn't actually say that. I think the contract says you always have to turn it over. But at the end of the day, if you're not going to cancel the contract, I would argue that it's of no concern to the seller.
Material.
It's immaterial.
All right. Thank you, Keith.
You're welcome.
Okay, let's go on.